Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today we're talking about Indigenous offenders and dangerous offender applications. Cases that should have gone to the Supreme Court of Canada, but didn't. Mr. Natto Megan was subject to a dangerous offender application. He was initially sentenced to 20 years in prison, followed by 10 years of supervision. On appeal, the Court of Appeal ordered an indeterminate sentence. Mr. Natto Megan applied for leave to appeal to the Supreme Court of Canada, arguing that his case raised very important issues that the Supreme Court of Canada denied to hear. And some of the issues Mr. Natto Megan raised in his application for leave to appeal are important issues that the Supreme Court of Canada should address. As we're looking more and more into the way that the justice system itself relies on systemic discrimination to ultimately achieve an unwanted goal of the over-incarceration of Indigenous individuals, the use of dangerous offender applications plays a significant role in resulting in the over-incarceration of Indigenous people as dangerous offenders and labeling Indigenous people who are otherwise not dangerous offenders as such. This is because the risk assessment process is based in inherent biases that work against Indigenous people. The Supreme Court of Canada had the opportunity to address how GLADU principles should play into the assessment of risk assessments when it comes to dangerous offender applications, and unfortunately they missed the opportunity. This is undoubtedly going to result in more individuals who are potentially not dangerous offenders, but are being assessed as such through a culturally incompetent lens, being given indeterminate sentences of imprisonment. And this is a significant concern. Hopefully the Supreme Court of Canada acts quickly to hear another case that deals with the question of risk assessments, cultural competency, bias, and the incorporation of GLADU principles before more Indigenous people get subject to more longer periods of incarceration that are necessary in our justice system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.